Right, good afternoon, everyone, and welcome to this week's webinar. Just some housekeeping before we get started. Please remember that these webinars are intended for educational purposes only. And while we do hope that you learn new information, the trainers that present these webinars are not attorneys. Therefore, all information provided during the presentation and the Q&A sessions should not be construed as legal advice. All right, now that we got that out of the way, happy 2021, everyone. To anyone I had not spoken to this year, this is going to be my first webinar this year, and I'm very excited to kick it off with a very, very fun subject, leaves of absences in the state of California. My name is Brianna Grimes, and I am the Senior Services Advisor here at PayEntry. And I'm very excited to present this webinar today. Remember that if you do have any questions during the presentation, please feel free to type them into the question box and they will be addressed during the Q&A session at the end. All right, with that being said, we have a lot of content to unpack, so let's get started. All right, so today we're going to be talking about what a leave of absence is, what employer obligations are there for leaves of absences. We're going to talk specifically about FMLA, which is a federally mandated leave. We're going to talk about the new CFRA, which is a leave located only in the state of California, but there have been some changes. So for a lot of you, this may be the first time that you're ever having to administer CFRA leave. We're going to talk about another federal law called the ADA that also has leaves of absences tied into it. And then we'll talk about some miscellaneous leaves in California as well. And then we'll end with a Q&A session. I'm seeing in the question box pop up. I do apologize, guys. We are still trying to work out the kinks with why sometimes handouts will not allow us to download them. They're all PDFs, but for some odd reason, GoToWebinar is having issues. I will email everybody a copy of these slides after this webinar, and I will send in another ticket. Sorry about that, guys. All right, so let's get started. So let's start with talking about what a leave of absence actually is. So a leave of absence is a benefit to employees which allows them to take time away from work to handle something in their personal life, and it also guarantees that their job will be waiting for them when they return. Now, leaves of absences can fall into one of two categories. There are mandatory leaves, where there are federal or state laws that actually mandate the leaves, and that these leaves have to be offered to employees by the employers. All of the leaves that we're going to be talking about today are mandatory leaves, and they're governed by laws such as CFRA, FMLA, ADA, things like that. The other category that leaves can fall into is voluntary leaves, where employers can opt in or out of offering the leave itself. Examples of these might be bereavement leave or personal leaves of absence or things of that nature. Now, when it comes to leaves of absences, especially in California, employers have some basic obligations that they are legally required to fulfill in order to protect their company. Now, employers are responsible for all of the following. First and foremost, they're responsible for determining what leaves of absence actually apply to them. So most leaves do have qualifiers in order for them to apply to your organization. It could be distance, it could be the employee count or the state the employee lives in or things like that. It is also your responsibility to know what leaves you are required to offer in order to stay compliant with the laws. You're also responsible for communicating leave resources with employees. Now, this can be done in a variety of ways, and all mandatory leaves should be mentioned already in your employee handbook. So employees have a quick resource for seeing which leave best fits their situation if they ever need to take one. However, in addition to your employee handbook, all of your managers should be trained on what leaves are available to employees or have one point of contact in your company that knows about the leaves that you can direct employees to so that way they get the correct information. The most important part of this obligation piece is that we highly recommend documenting these communications and transference of resources in writing. So emailing the employee the information on how to apply to things like FMLA or CFRA always works best. We don't recommend verbally informing your employees of these resources. The main reason is that if it ever came down to a lawsuit, you would have proof that the employee was made aware of all of the resources available to them. Now, as an employer, you can't force an employee to take a leave of absence, but you are required to make them aware and do your due diligence to provide the resources that they would need. Another responsibility is identifying reasons for leaves of absences and also proactively providing the resources. So, this obligation ties a little bit into the previous one I just talked about. Managers should be trained to identify the possible needs for the leaves of absences so they can provide the information ahead of time. Managers should also know what things like CFRA, ADA, and FMLA can all be used for. So, if an employee and a manager, for example, are in the middle of a one on one and the employee just happens to be talking about a possible upcoming surgery, your manager can immediately respond and offer them the resources that they need in order to plan for their leave of absence ahead of time. Not only is this a benefit to your employee, but this actually allows your company more time to plan for their leave of absence and be strategic in filling their roles and divvying out the responsibilities while they're gone. Being proactive with leaves of absences is key. Another responsibility is following up on leave of absence requests. It is not enough to simply give them the information and then wait and see if they apply. As an employer, you should follow up with the employee at least once to see if they have any questions on the leave of absence process or if they're ready to submit their request. This demonstrates that you're making a good faith effort to ensure the employee understands the information enough to use it. In the event of a lawsuit, this adds extra protection to your company and it shows that you did your due diligence to provide them as many resources as possible and assist them with the process if they had questions. Another responsibility is being compliant with the laws surrounding leaves of absences. This includes making sure that all protections are maintained and that the amount of time that was approved for the leave is complied with. Also, just anything pertaining to specifics surrounding that leave and making sure that all laws were followed in the event that the leave ends in a termination. Also, approving or denying leave of absence requests. So, if you are administering your leaves of absences internally, meaning you're not using a third party company to administer your leaves of absences, um, then you are going to be responsible for any medical documentation necessary and approving or denying the leaves based on that medical documentation that is provided to you. Now, a good best practice if you are administering them internally is that the immediate supervisor should never be the one to approve or deny the leave. It should always be a member of upper management or an HR representative removed from the employee's chain of command. Now, this person should definitely be trained on what leaves can be approved and what medical certifications look like when they're complete versus when they're incomplete. Also, communicating due dates for leave of absence materials such as application, medical certification due dates, and most importantly, return to work dates. This is one of the key obligations that a lot of organizations tend to ignore. It's actually your responsibility to make sure that the employee is aware of all due dates. That includes their return to work dates, any check in dates, any recertifications of medical certification dates, all sorts of things. Now, these notices should be done in writing, again, to ensure that there is documentation to prove that these notices were provided to the employee. This is the only way to really hold the employee accountable to these dates, is if you have kind of a paper trail of the notices that went out. Now, if you approve a leave of absence, for example, and you never specify a return to work date, and then you terminate the employee when they don't return at the end of the 12 weeks that was approved, well, then that employee may choose to file a wrongful termination lawsuit. And it's very likely that you will lose because you don't have the documentation of your expectations communicated to the employee on the exact return to work date and the process entailed with them returning to work from a leave. Another responsibility is requesting and verifying all leave of absence documents, and that ensures that you are making sure that you receive the medical certifications in a timely fashion, that they're filled out appropriately, and that the information provided by the healthcare provider is specific and clear enough for you to make a determination on whether you can approve or deny the leave. And lastly, following up with employees to return to work. Again, it is so important that you follow up and make sure that they are aware of their return to work date, that they have submitted any proper return to work authorization form that you require from their doctor, just to verify that they are fit for duty and to make sure that they don't need any additional accommodations. Overall, there are a lot of aspects to leaves of absences that should be taken seriously and, of course, documented appropriately. If you're not currently taking all of these steps in administering your leaves of absence, you could be opening yourself up to a potential liability. Now, next, we're going to talk specifically about each of the big leave of absences that you should be familiar with. And we're going to start with FMLA because that is the biggest one. So the first mandatory leave of absence we will be talking about is FMLA, or Family and Medical Leave Act. This leave is regulated on the federal level and it applies to all companies across the US who fit the eligibility criteria. So employers who have 50 or more employees within a 75-mile radius of each other are required to offer this leave of absence. Employees may then use this leave if their employer is covered if they worked 1,250 hours in a 12-month period prior to the start of their leave, and they had to have worked for their employer for one full calendar year. So these are the criteria or examples of criteria that you would have to track if you're administering your leaves internally. Now, if the employee and employer meet all of these eligible criteria, then the employee is then entitled to up to 12 weeks of unpaid and protected leave of absence in a rolling 12-month period. So what that means is that if Sally takes a leave of absence starting in July of 2021, her leave will be available to her again starting July of 2022. It does not reset at the beginning of a new calendar. It functions on a rolling calendar year. In addition, this leave or FMLA leave can be taken on an intermittent or a consecutive basis. Now, there are very specific reasons that certain leaves can be taken, and FMLA is no exception. So employees can only take FMLA for any of the following reasons. They can take it to care for and bond with an employee's newborn child or newly placed foster or adopted child, to care for a family member with a serious health condition who is the employee's spouse, parent, or child under the age of 18 or who is over the age of 18 but unable to care for themselves. They can take it for their own serious health condition that makes the employee unable to perform their job, the employee's own medical disability related to pregnancy and birth, a qualifying military exigency related to the covered active duty or call to covered active duty of an employee's spouse, parent, or child in the U.S. Armed Forces, and military caregiver leave for a service member with a serious health condition who is the employee's spouse, domestic partner, child, parent, or next of kin. And this type of leave is eligible for up to 26 weeks of leave in a rolling 12-month period. Now, I'm sure some of you might be asking, but wait, okay, so they go on this leave, it's an unpaid leave. How do they get paid? Who can afford to take 12 weeks off without a paycheck? Well, as employers, employees actually have a couple of options that you should be familiar with most of them. Employees are able to use paid sick leave that they have accrued, PTO, or vacation time. And as employers, you can actually require at the beginning of their leave that they take or exhaust their PTO or vacation time first before utilizing things like short-term disability or any other forms of paid leave. In the state of California, they actually offer paid family leave benefits through the state for individuals who need to take time off to care for a family member. They can also use it for bonding with their baby or for the military exigency. The employee may also apply for short-term disability through the state, but only if they have paid into it, and only if the leave is taken for an employee's own disability. They will not be able to apply for short-term disability for caring for a family member. Also, some employers choose to be generous and opt into offering a certain amount of time for paid leave. It could be up to 2 weeks of paid leave for baby bonding or 4 weeks of leave if you have a major surgery. Now, these are not required, but you do have the option to offer them. And I know I've seen quite a few employers ask specifically or offer specifically maternity leave. And we are recommending that employers stay away from maternity leave, and we call it parental leave or baby bonding, because there are discrimination cases that have come up that the men are being discriminated against for maternity leave, that they can't take the time off to be with their newborn. So we are recommending that employers begin to offer leave, and it has to be offered equally to both parents, both the male and female parent. Now, another question that often gets raised is about benefits. So what is an employer's obligation as far as benefits go? Well, as an employer, you are obligated to maintain coverage during their FMLA leave on the same terms as if they were continued working, as if they were an active employee. Now, employers can choose to either make the payments on the employee's behalf and then recoup the funds in arrears when they return, or you can require the employee to make the payments while they're on leave. So now that we've covered kind of the basics of FMLA, FMLA, like I said, is the most common leave, but I want to touch on the new CFRA leave because a lot of the changes to the new CFRA leave affect FMLA if your company is required to offer FMLA as well, but also because you'll see a lot of similarities between CFRA and FMLA. All right, so if you were with us for the California State Update mini-series, some of this information should look familiar to you, but the new CFRA law affects a lot of employers for the first time. So we're gonna go ahead and review it again because I'm sure some of you may have questions on what this means for your organization now that you have to offer this leave. So this law went into effect January 1st of this year. So we are 14 days into the practice of this law for some employers. And essentially this new CFRA, it repealed the California New Parents Leave Act, as well as the original CFRA, and it replaced it with this brand new CFRA. So let's take a look at some specifics on this new CFRA in 2021. Companies with 5 or more employees are now covered by this act. So if you have 5 or more employees, you are now legally obligated to provide this leave. Previously, it was 50 or more employees. So it was almost identical to FMLA, what we just went over. But this year, California decided to lower that requirement, and now all employers with 5 or more employees have to offer this leave. The qualifications are very similar to FMLA. The employee does still have to work that 1,250 hours in a 12-month period in order to be eligible to take this leave. And the employees are eligible for up to 12 weeks of leave in any 12-month period, and this time can be taken either consecutively or intermittently. Now, this leave can run concurrently with FMLA leave as well, and we're going to talk about what that means in a few minutes. So let's look at what CFRA can be used for. Well, before I answer that, it's a good idea to know that there are a lot of reasons covered by FMLA that are also covered by CFRA. So again, like I said before, you're going to see a lot of similarities. So as far as CFRA goes, you can use CFRA to care for and bond with an employee's newborn child or newly placed foster or adopted child, to care for and bond with a domestic partner's newborn child or newly placed foster or adopted child, to care for a family member with a serious health condition who is the employee's spouse, parent, or child under the age of 18 or over the age of 18 and unable to care for themselves, to care for a family member with a serious health condition who is the employee's domestic partner, child of a registered domestic partner, sibling, grandparent, or grandchild, an employee's own serious health condition that makes the employee unable to perform their job, and a qualifying military exigency related to the covered active duty or call to covered active duty. Now on this slide, I have marked in bold any reasons that are covered by FMLA as well as CFRA. So these should look familiar to you from the previous slides. Any bullets that are not in bold are only covered for CFRA. So I want to go back to what I said earlier about these leaves running concurrently. So any bullets that are in bold can run concurrently, and any bullets that are not in bold will not. Now, the best way to understand this concept, for me at least, is to look at examples and walk through concepts with illustrations. Sometimes it's just easier to get a visual on what running concurrently really means. So let's take a look at some examples. Now, before I go over the first example, I just want to preface that all of these examples, in them, we are assuming that the employees meet all the criteria to be eligible for the leave entitlement, and that all of these leaves were approved through the proper leave of absence process. So let's start with the first example, looking at an employee ready to take a leave. So Diane is on a leave of absence because she has to have a major medical surgery not related to pregnancy or birth. She's expected to be out for the full 12 weeks. So let's visualize Diane's leave. Starting from week 1 all the way through week 12, both CFRA and FMLA would run together because they both cover an employee's own serious health condition. Therefore, at the end of her leave, Diane will have exhausted 12 weeks under FMLA and CFRA, and she would have no leave entitlement left for that year under these two laws. Let's take a look at another example that's a little bit more complicated. So we're going to take a look at our friend Christopher. He has a lot going on in his life right now, and FMLA and CFRA are here to help him. So Christopher is taking a leave of absence to care for his ill grandfather, and he's expected to be out for 6 weeks. Visualizing Christopher's leave, we can see from the diagram that only CFRA covers caring for a grandparent. That reason is not covered under FMLA. Therefore, Christopher would have exhausted 6 weeks of leave under CFRA. That leaves him with 6 weeks left under CFRA and the full 12 weeks left under FMLA because he didn't use any. But like I said, Christopher has a lot going on in his life right now, and once he gets back from his leave, he has to immediately take another leave of absence. After finishing caring for his grandfather, Christopher must have a major surgery due to a medical condition, and his recovery is estimated to take 4 weeks. So in Christopher's new diagram, we see that he has now used 10 weeks of leave in total. These new 4 weeks of leave for his surgery are covered under CFRA and FMLA because, like Diane, they both cover an employee's own medical condition. Therefore, at the end of his leave, he would now have only 2 weeks left under CFRA and 8 weeks under FMLA. But again, Christopher's life was really eventful in 2021, and he requested a third leave of absence shortly after he returns from his surgery. During all of this, Christopher's wife is actually pregnant, and she gives birth shortly after Christopher returns from his recovery. So now he's going out on baby bonding leave. Let's take a look at his final leave diagram. His last 2 weeks of leave under CFRA will run concurrently with FMLA for baby bonding because both of these leaves cover baby bonding. At the end of those 2 weeks, CFRA has been exhausted, but Christopher still has FMLA leave left. So Christopher takes the remaining 4 weeks of FMLA leave for baby bonding, and then he requests to use 2 weeks of PTO he saved up at the end of his leave to finish his baby bonding before returning to work. So at the very end of all his leave allotment, Christopher took a total of 14 weeks of protected leave and 2 weeks of approved PTO. So he was out for a total of 16 weeks. Now, just like we talked about in the examples, some leaves are covered under both and others are not. That is why there is now a greater risk for small employers having to now be required to offer upwards of 24 weeks of leave in a 12-month period because of how the CFRA has expanded their reasons for leave. Now, if your organization is 49 employees or less, then obviously CFRA is the only one that applies to you. But if your organization has 50 or more employees, you are legally required to offer both CFRA and FMLA, and an employee has a potential to legally take up to 28 weeks of leave in a calendar year. Now, if FMLA does not cover some of the reasons for taking CFRA, then that new CFRA would be used first, and then the employee could use their FMLA time later that year. And that's where we get the 28 weeks, the 24 weeks, my apologies, 24. So these are the types of leave nuances that are very important if you are administering your leaves internally. Now, a question that I get a lot of the time is, well, what happens when an employee exhausts all of their leave and they have nothing left, not even PTO? Can you just fire them if they can't return to work for, failing to return from their leave? Well, the answer to that is it depends because of the next law we're going to look at. Next, we're going to talk about the Americans with Disabilities Act, otherwise known as ADA. Now, this civil rights law prohibits discrimination against individuals with disabilities in all areas of life, including work. So, if an employee is out on a leave due to a disability and they are unable to return to work and they have exhausted all protected leave, then they would still be protected under the ADA. Now, the ADA requires employers to engage in what they call the interactive process between yourself, the employee, and their healthcare provider to see if there is a way to reasonably accommodate the employee with the disability. Now, the most ambiguous part of this whole process is the term reasonable. What is reasonable to you as an employer may not be reasonable to the state of California and their court systems. In fact, in California, a leave of absence continuation is considered a reasonable accommodation. And the longest recorded reasonable accommodation that has ever been accepted in the court system was 2 years long. So I encourage you to reach out to Kathy and myself or an employment attorney if you ever find yourself in a situation with an employee where they have exhausted their leave and you're not sure if you can terminate them for failure to return to leave. It's best to talk it through with a professional so that way you get an idea of how much liability your organization might be taking on if you decide to terminate an employee that may be protected under the ADA. Now, the interactive process itself is all about documentation. You have to document your notice to the employee that you are engaging in this process, and you need to document reminders, notices, follow-ups, approvals, denials, delays in the decisions. Anything that you communicate with the employee must be documented. The ADA loves their documentation. Another thing to keep in mind with this is that the employee actually does not have to ask about the ADA. The obligation is on the employer to engage in this process, even if the employee doesn't know about it. It's your responsibility to suggest this for any employee that you believe to have a disability and would need a reasonable accommodation, even if they're not on a leave of absence. So just because the employee exhausts their leave and does not request an extension under the ADA does not mean that you will win in the event of a discrimination claim, because it's actually very likely you'll lose because you did not engage in this process. So this is something that the ADA takes very seriously. Now, outside of medical leaves, there are many other miscellaneous leaves offered in California that should also be included in your employee handbooks. We're going to go over a couple of them here. So the first one is school activities leave, and it must be provided by employers with 25 or more employees. This leave allows employees up to 40 hours per year of time to participate in activities at a child's school or daycare. And this leave is not to exceed 8 hours in a single month. The next one is jury duty leave. So all employers must allow employees the right to take time off of work without fear of retaliation to perform their civic duty of serving on a jury. Now, this leave time can be paid or unpaid at the employer's discretion, and employees must have the option to use PTO or vacation time to cover the leave if they choose to, if the employer is making it an unpaid leave. Another one is voting leave. Employers must allow employees up to 2 hours off to vote at the beginning or end of their shifts, whichever allows the employee a larger voting time window depending on when their shift starts or ends. This time off is mandated to be a paid time off. Another leave is domestic violence leave. All employers must allow employees time off to obtain restraining orders or seek other judicial relief from any type of domestic violence or sexual assault for the employee or their child. Now, if the employer has 25 or more employees, they must also provide unpaid time off to seek any type of medical treatment, obtain services from a rape crisis center or a shelter program, receive counseling, or engage in any type of safety planning or relocation. And then there's also bone marrow and organ donor leave. So employers with 15 or more employees must provide up to 30 business days of leave each year for employees to donate an organ and up to 5 business days each year for an employee to donate bone marrow. And this leave must also be paid. Okay, so I know we went over a lot of information today, but in summary, my recommendations as far as action items with this information to take this away to your designated employers in California would first and foremost be become very familiar with the leaves that you are required to offer, especially because this new CFRA leave is now required by employers with 5 or more employees. Many of you may be having to administer a leave of absence for the very first time. And it's a very time consuming and administrative intensive process, as you can see from some of the slides that I presented today. It is also a process with a lot of liability because you're now handling medical documents and information that you may not have otherwise been privy to. So please educate yourself on these processes and the laws surrounding these leaves of absence. Also, big one, update your handbooks to be sure that you include all the leaves that you are required to offer. California requires a lot of leave laws for employers, and your handbook is the first resource you should turn to for information for your employees. It is also a great resource, but only if it's updated. So keeping it updated is going to make it an even better resource. Now, if you would like Kathy or I to review your handbooks and update them, please reach out to us after this presentation and we can definitely get you pricing on that project. But I promise it is an investment in your company to have an updated handbook. Another kind of added bonus to updating your handbook and keeping it updated is it serves as a form of documentation to help support that these employees had access to information on leaves of absence. So if for some reason you had a manager do everything verbally, and they had no documentation or their email got wiped or something crazy like that happened and you end up in a litigation case, you do have the availability to say, hey, my employee signed this new handbook that we rolled out 2021. It had all the leaves of absences in it, so they had access to these resources. So it does add a little bit of extra cushion in case your manager really doesn't do what they're supposed to do from a documentation standpoint. Also, if you choose to administer your leaves internally, please, please, please learn how to administer them correctly. This includes learning how to document. I don't know how many times I can say it, but document everything. Leaves of absences require a lot of documentation to mitigate the liability that you take on by administering them, and it must be done properly in order to serve its purpose. Now, if all of this seemed a little overwhelming to you and a lot of information on administering leaves, and doing so is something that you really can't handle on your plate right now, or it's just really a lot for your organization right now, especially with CFRA affecting you if you're a smaller employer, I would say that you may want to consider one of our HR services packages that we offer through PayEntry. If you are a payroll client, you do get access to Kathy and I for general questions, but some organizations definitely want and need that next level of care. So they use us for project work, or they need a virtual HR manager, or just someone to help develop these processes that you may have to, build from scratch. But at least we kind of give you a diving off point. So if you're interested in taking a look at any of the packages or services that we offer, please reach out to me at the conclusion of the webinar and we can definitely review our options with you. I know that being an employer in California can be very difficult. All of my HR experience comes from California. I've done California HR for 10 years, and it's only gotten more difficult in the 10 years that I have been doing it. So we definitely want to make sure that, mine and Kathy's passion is HR. So we want to take care of the things that we're passionate about for you, so you can grow your business and do the things that you're passionate about. Because I'm sure for some of you, HR is not your passion, but we want to make sure that your businesses still thrive and stay compliant, and understand kind of how HR and the laws fit into your organization. All right, well, like I said, I know that was an exorbitant amount of information to process, so take a second right now and ask any questions that you have via the question box. Just as a reminder, this presentation was recorded and it will be available to watch again. To do so, you can visit our website at www.payentry.com. You can hover your mouse over the webinars tab at the top and click on webinar recordings. The most recent recordings are usually on top and they are usually posted within 24 hours of the live webinar, so they will be posted by tomorrow. You also typically receive a emailed copy of the webinar within 24 hours of the webinar if you registered or attended. All right, so let's see what questions that we have. All right, it doesn't look like we have any questions, guys. I know it's probably because I threw so much information at you. But if after processing and, kind of sitting on and marinating on this information for 24 hours, if you come up with a question, feel free to reach out to me. I'm available at any time. Again, here's my contact information on this next slide. Next week, we are going to be talking about labor law posters, both the federal and state requirements and kind of what that looks like, especially if you have moved into an entire remote work setting. Labor law posters are going to be a little bit different for you because obviously one of the requirements is posting them in a general area that everyone can see them. And if your staff is working from home, that's a little difficult to do. So we are going to talk about those types of requirements and answer any questions that you all have. But we definitely look forward to seeing you there. Again, if you guys have any questions, my contact information is on this slide. Feel free to utilize it. Email me, ask me questions. I look forward to speaking and working with all of you in 2021. Well, thank you all for joining us today. I hope you got some good gold nuggets of information, and we will see y'all next week.